This is our jury selection research project. Our topic is jury selection, done by Liz Garcia, Gabriel Castro, and Minora. So starting off with our thesis, which was, although jury selection is an imperative part of the court process, it has been shown to be biased and manipulative at times. Jury consultants can distort the core values of the criminal justice system and further shift their purpose to become a biased tool in a lot of cases. Our main topic is how jury selection can be used kind of in a wrongful way, and discrimination is also a big part of it. So starting off with the background of jury selection. So voir dire is interpreted from the French as to speak the truth, while others might interpret the phrase simply as to see to speak. And then a more broad definition of the way it is kind of used today is pretty much the process of questioning for possible jurors to determine whether they're biased or other qualifications prevent them from the service they will provide as being a juror. Over the course of the years, the forms of selecting the jury, composition of the jury, and the overall function of the jury has changed a lot with time. Originally, the jurors would be selected based on the fact and knowledge they obtain on the case. Now, in time, it's actually the complete opposite. They're kind of selected based on the ignorance of the facts, and it's better when they don't know anything about the case or don't have any type of relation to it. Back then, there would also be a lot of manipulation with the jurors. They would pick some that would be highly influenced by the crown and making it easier for them to get the decision that they wanted. And now in today's justice system, it's based on fairness and integrity, so a lot of that has changed. So the whole process of jury selection begins with the court clerk summoning 12 people on the jury list, or it could be 12 or less. It kind of depends on the trial. But then the request has a brief statement of the case and will inquire whether there is a reason as to why the juror might not be able to serve. So that's the summoning part. Then the voir dire part is pretty much the section when the judge or the lawyer starts asking them questions about their knowledge of the case, and if any specific life experience they might have can cause them to be biased towards the case and just make an unfair judgment. So if it comes to the case where the lawyer feels as if the juror is prejudiced towards the case, that's where the challenging part comes in, and he or she can kind of dismiss the juror for a certain cause. So the challenges by cause pretty much is when the lawyer gives a cause for why he wants to excuse that juror. But then there's also the peremptory challenges where pretty much they don't have to give the cause or show any specific reason. They do have limited when it comes to the peremptory challenges, but the other one is unlimited. So once both parties agreed upon a jury, the jurors are pretty much sworn to try the case, and then they're said their role is to listen to the evidence and not really make any conclusions based on anything else apart from the evidence. And they're also told that they can't discuss the case with anybody else outside or with each other in general. So the Batson challenge is a challenge made by one party in a case to the other party's use of the peremptory challenge to eliminate potential jurors from the jury on the basis of sex, race, ethnicity, or religion. So it's pretty much, it was developed through the case Batson versus Kentucky, and the process is used against another party when they have a reason to believe that there was discriminatory bias used when excluding a juror. There's a process to it, which is pretty much the defendant must present evidence to show the prosecutor made the challenge based on discrimination, and then the prosecutor must provide a kind of a statement given his explanation for the strike, and it can't have any type of discriminatory action in it. And then lastly, it's up to the judge to decide whether the prosecutor kind of gave a sufficient explanation of why he struck the person. Now, as we all know, not everyone kind of qualifies to be a juror, and these are pretty much the basic qualifications to be a juror here in Florida. So first of all, you have to be at least 18 years of age. You have to be a citizen, a legal resident of a county in the state of Florida, and you must hold a Florida driver's license or identification card issued by the DHSMV.
When it comes to bias in the jury selection process, two major cases come to mind. The first is Batson versus Kentucky, where it was found that the prosecutor unjustly striked four potential black jurors, which led to an all-white jury, which then led Batson to being charged. And Flowers versus Mississippi, where the Supreme Court reversed the judgment of the Supreme Court of Mississippi because they stated that it was wrong to conclude the state's irreversible strike of a possible black juror wasn't racially charged. Overall, these cases accurately portray how the jury selection process can be incredibly biased and result in an impartial jury. Another device that can be used in the selection process are jury consultants. Although they are a biased tool that can distort the values of the court, they can be used for good, being that it is the defendant's constitutional right. The argument that jury consultants provide an upper hand to those who can afford it, therefore making it unfair, is one that can be used in other instances. It could apply to other trial-related services such as hiring the best legal counsel and expert witnesses. With those resources, there is a better chance of success in trial, which can generally be seen as unfair to those who can't afford this luxury. An additional concern about how potential jurors are chosen or rejected is the ethics of the process in relation to social media. Although not explicitly unethical, several resulting factors make some question the method. The main concern is the invasion of one's privacy. Researchers believe that the investigation of one's social media can have undesirable effects. On the other hand, it can be argued that this information is publicly available. This gray area further illustrates how the selection process can be manipulated and used to a side's advantage.
Another factor that comes into play in the justice system is the use of jury consultants. So these people, they're usually psychologists, and most of them usually have PhDs, almost like half of them do. And what these people do is that they use social sciences and different research processes to make mock trials in which they find the best evidence that needs to be used during a case and the juries that would best help others, such as either the defendants or the prosecutors, in getting the result that they want. Now, the problem that this rises is that this could be very unethical because what these people are trying to do is use biases in their favor. They use social sciences in the courtroom, and this is to get um, an idea of what the jury or who the jury will decide or plead against or for. And this could be very detrimental to the trial. And what they try to do is find the biases of different juries and try to exploit that and try to get the result that the client wants. Another thing that can be very unfair is the pricing of these jury consultants. Um, they can be used they're mostly used for high profile cases such as the case of O.J. Simpson, where they used a lot of jury consulting. They used it in order to get the jury that they thought would get them the best result and the best chance of getting not guilty, and it clearly worked. And it is not the only reason